All right. Good afternoon, America. This is Fair Housing. It's the law. And I am Michael Smith along with.
I'm MJ Borelli, and we're both with the Fair Housing Council of Central California. And what we do at the Fair Housing Council is we receive complaints from viewers like you in regard to housing complaints that deal with discrimination in housing, generally based on race, color, national origin, religion, gender, disability, or family status, which is about folks that have minor children in the household, whether they're related to them or not. At the Fair Housing Council, we receive all kinds of complaints, some of which are not necessarily about discrimination, but suggest policies that landlords or property management firms might have that could have a negative result to all of those folks that are protected under the Fair Housing Act, i.e., because of their race, color, etc. One of the things that we've been hearing quite a bit lately has to do with disabled tenants. The question is, I'm in a wheelchair and I live in an apartment that has a situation where I can't get in and out of the front door, and I need a ramp. And the question is, does my landlord have to put that ramp in, supply that ramp, and pay for it? And the answer to that question is probably not. There is a portion of the Fair Housing Act, a 1988 amendment to the Act, which adds disability as a protected area under the Fair Housing Act, that speaks to the issue of reasonable modifications of the property. In other words, if you're disabled and you need to have some sort of a modification that's physical to the property that you rent, apartment, for example, then generally speaking, you need to be allowed to do it. You need to be able to make that modification, so you have to straight up ask the landlord or the management folks, whoever it is that you deal with, for maintenance issues or day-to-day types of things. And they have to allow you to make these modifications. Now, keep in mind, the working word here is reasonable. So, major structural modifications might not be considered reasonable. But let's just say you want a ramp outside your doorway. If this is a regular apartment complex, i.e. there's not any kind of subsidy going on, it's not a project-based Section 8, it's not public housing, then the landlord must allow you to make these modifications, like addition of a ramp. But it's going to be at your own cost. Now, if you happen to be so lucky as to live in a subsidized housing situation, public housing, project-based Section 8, for example, then the landlord is going to be required to assume the cost of such a ramp. Reason for that, pretty obvious. These are complexes that are receiving millions of dollars in subsidies over the years from the federal government, so they have to pledge to the government that they are providing a safe and accessible place to live. So if you happen to be in that kind of a situation, then, they're going to have to do it and install it. But for the most part, most properties out there are what we call just market properties, private market properties, and you would have to bear the cost. Now, this can get tricksy. It can get tricksy in that sometimes there's not an easy way to modify for something like a ramp. and I know we've discovered this recently on an inspection of a property that we have a complaint against. Could you describe that property?
The property was the exact complaint was about the stairs, and the stairs was two big concrete blocks that wouldn't be impossible to get a wheelchair up there. But if you ever had to pull somebody upstairs in a wheelchair, this would be it would take a lot of strength to do.
Well, and I might add that this is a ground floor apartment that for some reason was developed with a small concrete porch and steps down to street level, like 3 steps or 2 steps.
It was
anyway,
like 2 big block steps that was like huge.
Not accessible if you're in a wheelchair walker or using a cane. It's going to be difficult too. I couldn't even figure out why they were developed. And a little sidebar here, that 1988 amendment to the Fair Housing Act that includes disability as a protected area also talks about design and construction requirements under that statute for complexes where the first tenants move in after March 21 of 1991. Any complex has to have these accessibility features, like an accessible route in and out of the apartment. In other words, they should not be developed with porch steps on a ground floor apartment that make it difficult for somebody who has a mobility disability, i.e. they are using a wheelchair or a walker or a power chair. It's just going to be impossible. And we were amazed. This particular complex looks to have been developed right on the cusp of those statutory occupancy times. And so it looks as though the cost will be borne by the tenant, either with a portable kind of ramp, which, what they cost, I have no idea. Sometimes there are programs out there, and if you happen to be mobility disabled and have the same problem, sometimes it's difficult to pay for these modifications. Now, there's a pretty famous case that was a HUD administrative case back in the early 90s that had to do with a man who was confined to a wheelchair. And he had a complaint against the Ocean Sands condominiums in Miami, Florida. And this was a very high-end condominium development, and this gentleman was going to purchase a condominium there. He was confined to a wheelchair because he suffered from heart complaints such that he just couldn't get around walking. And he had been recommended to live by the ocean, that the sea air and the sunshine, etc., was going to be something to help his particular chronic condition. So he buys this condominium, which is right on the beach, but he has no accessibility to the beach. There's no ramp from the property for a wheelchair to enter this beach. So since it's a condominium, there is a homeowners association. So he went to the homeowners association to see if he could modify his property so that he might build a ramp to the beach and therefore enjoy what everybody else who was not disabled and not confined to a wheelchair. But he ran into great difficulties. He couldn't seem to please all the folks on the HOA, the Homeowners Association. He had to hire a contractor, had to pull permits from the city. It was a very expensive undertaking. And so when the homeowners association at Ocean Sands Condominiums there in Miami finally okayed his plans to modify the property so that he would have access to the sea there, he went about building this ramp at a great expense. When it was finally finished, the homeowners association decided they didn't like the looks of it. They didn't like the looks of it, and they didn't like the looks of, a guy using a wheelchair using it where everybody could see. He had even landscaped alongside the ramp, tried to make it as attractive as popular. As I say, he went to great expense. And the homeowners association said, you're either going to pull that thing out or we're going to fine you. So this went on for a long time. He filed a fair housing lawsuit with HUD. And this was dragging on for such a long time, he died before there was any resolution. So this lawsuit was also about not only his claim for a reasonable modification to the property to allow him equal opportunity to use and enjoy his particular dwelling, which he owned, but now his surviving wife, it was ruled by the administrative law judge that she had standing to continue in the lawsuit against Ocean Sands. And they eventually did prevail and didn't have to tear apart the ramp. And there is a point of law within the 1988 amendment that says you are making these modifications at your own cost, and then they must be restored to their original state if you ever should move out. Well, they owned the property. She wasn't going to move out anytime soon. And the point of this is, if you're a landlord or owner or a property manager, you have to allow these undertakings and not put restraints to such a degree that it would be like you're saying, no, you can't do that. Now, there is a companion to reasonable modification in fair housing law, and we often hear this term reasonable accommodation, which is about something else entirely, and as a tenant shouldn't cost you a thing. A reasonable accommodation is about some change that you're requesting because of your disability that might deal with the policies surrounding your tenancy at a complex, a rental complex. Although the need for a reasonable accommodation might also come up with those people that rent single-family homes or mobile homes. So if you're disabled and you're in any kind of a rental, you certainly have a right to a reasonable accommodation in the terms, rules, and conditions of your lease or rental agreement to allow you once again to have equal opportunity to use and enjoy your dwelling just as a non-disabled person might. So some examples of a reasonable modification might be something like, because of my disability, my assigned parking place is really not accessible for me. So I'm asking management now for a more accessible, perhaps closer, assigned parking space. And we get these kinds of needs and complaints all the time. And it's interesting to me how landlords and property agents come up with almost the same retort when we contact them about a client who has this need. And that retort is, well, if we do it for that person, we have to do it for everybody, otherwise we're discriminating. And my answer to that is, that's poppycock and that's wrong, wrong, wrong. Reasonable accommodations for a disabled tenant are special. They're a protected class under the Fair Housing Act. And you need to listen carefully. And if this person is asking for this kind of a situation so that they can just come and go and live their everyday life, you need to pay attention to it. You are obligated under the law, especially if there's been a nexus established between that request and the person's disability. The other thing we often hear from the landlords or the property guys is, I didn't know that guy was disabled. And what kind of disability does he or she have anyway? Well, once again, you can't ask. It's against the law for you to ask, what is the nature of your disability? You can ask a person, oh, you are disabled? Yes, you can ask them that. But unless that tenant or home seeker doesn't want to add much to that, you can't ask. But you do have to enter into what is known under the law as an interactive process, which means stuff like, why do you need that close parking space? Well, because of my disability. I have trouble getting from here to there. I may not look like I'm disabled, but I have trouble getting from here to there. In fact, I even have a doctor's prescription here that says I need to have a parking place closer to my rental unit. So now you really have to prick your ears up and understand that this person is declaring that they have a disability and they're just asking for something that's more accessible to them. And you're not discriminating against the rest of your tenant population by providing this reasonable accommodation. Actually, it's required that you do this by law. And what happens if you don't do this, if you don't give that reasonable accommodation, or you don't allow that reasonable modification, short of, in the case of a physical change, somebody's not tearing down a doorway or knocking out a wall. Well, the law says that you can be sued in federal district court as the landlord, and you're going to have to pay attorney fees, court costs, penalties, punitive damages, and compensatory damages. And that's what happens with these kinds of things. And the Fair Housing Act and its 1988 amendment is very pointedly directed folks like fair housing councils who represent these kinds of folks that this is the action that can be undertaken. And if you're a landlord or a property guy out there listening to this broadcast or watching this broadcast at the moment, I think you need to note how much it costs once one of these claims gets to federal district court, just from the initial filing to summary judgment. You're talking about an average from anywhere from $350,000 to $450,000 in attorney fees and court costs alone. And that might be just one side of the equation, because if you lose in one of these actions as the landlord, then you have to pay the attorney fees and court costs as well as compensatories and whatever else the court might demand, not only to that plaintiff who's the complainant, but of course you're also going to incur those charges from your own representation. So it's important that you note that the Fair Housing Act and your obligations under the Act, and this is just one area involving disabled tenants, is very, very serious. As serious as a heart attack, and it costs money, and it's very, very expensive. As far another note about this interactive process, the interactive process really is talking about as long as there is a discussion going on between you as the landlord or landlord's agent, and the disabled tenant, that's a good thing. You're trying to figure out exactly what the need is as the landlord, and you're trying to determine, is this a reasonable request? Is this going to present to me an unfair administrative or financial burden? Because if it does, then it may not be a reasonable request. So these kinds of things are going to go back and forth for a while between you and the tenant. But one thing you need to note, and that is that if you take too long going back and forth and depicting this as your interactive process, then it's the same thing as saying no. If you're making a person wait months and months and months and months. I also wanted to add on to the example of an accessible parking place request. A lot of landlords and landlords agents, property guys, misconstrue this and think what they have to do is to erect a regular handicap space with the little blue sign where you have to display the blue placards that are administered by any state's Department of Motor Vehicles. Well, the problem with that is that's a more of an ADA issue. That's about public access. Anyone can park into a handicap space that displays either the special handicap license plate that usually has a blue wheelchair icon on it, or you're displaying the blue placard. Anyone who has one of those can park in that spot. It's about public access. Doesn't mean that you can have that spot exclusively. So I've had landlords that tried to create the accessible parking space in this way, and you don't want to do that. That's more problems, and that's not what your person is asking for. All you need to do is you decide between you what's available, what's accessible. Maybe you put up a little sign or spray paint it on the selects parking space itself that this is for the tenant that lives in, for example, unit number 6 only. All others might be towed away. And that parking space is only for the use of that tenant at unit number 6.
I think I've seen in some places where they did that, they put reserved.
Yeah, reserved for apartment B or whatever. I've seen that as well. But I remember we had one case that was in a rural community where the landlord went to great expense to erect a regular parking space with the handicap sign, etc. Wrong. That's not for one individual's use all the time. That's for anyone who displays the special placard or the special license plate.
So I can still come home and not have a place to park because someone else who's handicapped.
That's the last thing you want to do. Yeah. I mean, cool if you're adding such a space for, public, for the public to use. But we've had to ask landlords, well, you can't do that. You might have to tear that down if this is the space that you selected. Otherwise, thanks for listening. If you have yourself any particular issues surrounding a fair housing complaint, please contact us at the number below, 559-244-2950, or toll free. We're in Fresno County in Central California. If you're anywhere in the state of California, you can call us at a toll-free number, 498 FAIR, FAIR, and we will entertain your request. So thanks so much for tuning in.
Fair housing is